We are all here. Good afternoon, everyone. Welcome to OCRC, the Ohio Civil Rights Commission's Legal Updates, Statutory and Case Law. I'm Sandra Lee. I'm with the Department of Administrative Services. I'll be moderating this session. Just a few housekeeping items, and I will also drop these into the chat box, but we invite you to submit your questions or comments in the meeting chat. The presenters will do their best to address these during the course of the conversation. This session is being recorded and may be posted online, or it may be available for on-demand access. You must complete the knowledge check and course survey to receive the CLE for 1 credit hour if you're here for the CLEs. You must also attend this session live. No credit will be provided for reviewing the recording. The review and the survey link will be posted in the chat. Please submit both the survey and the review by Friday, August 26th for CLE credit. You will need to include the program name, which is the OCRC Overview of New Statutory and Case Law. Activity code is 497481, and I will drop that into the chat. And if you have questions regarding CLE credit, you can reach out to Chelsea Wansky. Okay, now, so let's get started. Allow me to introduce you to our presenters for this session. We have Bradley S. Dunn and Christy Lambert. Bradley Dunn is an administrative law judge for the Ohio Civil Rights Commission. He's been employed by the Ohio Civil Rights Commission for 26 years. And he has also held the position of legal intern, investigator, field supervisor, reconsideration supervisor, regional director, and interim general counsel. He's also been the recipient of the Commission Employee of the Year and Above and Beyond awards. Bradley has served on the Board of Trustees from 2017 to 2020 and is the 2022 recipient of the Association's Diversity Award. He currently sits on the Board of Directors for Project GRAD, is a barrister in the Scallon Bell End of Court, a member of the Akron Canton Barristers, a fellow in the Akron Bar Fellowship, and is the recent recipient of the Black Law Student Association John Goodwin Jr. Big Heart Award. Bradley currently resides in Hartville, Ohio, with his lovely, much more talented wife, Amy, and 2 young children, Spencer and Madeline. Christy Lambert, as general counsel, serves as a primary legal advisor for the Ohio Civil Rights Commission. She advises the executive director and commissioners on all legal matters, and she coordinates and directs all legal activities of the agency in multiple areas of litigation. Before joining the commission, Ms. Lambert served for 8 years as an assistant attorney general for the Ohio Attorney General's Office, where she represented a wide variety of state boards, commission, and cabinet agencies in administrative and civil litigation. And now please help me welcome Bradley S. Dunn and Christy Lambert. The floor is all yours.
You think after 2.5 years I'd learn to unmute myself. Thank you so much for that great introduction. I don't know how I'm going to follow Brad with all of his awards and everything, but my name is Christy. As introduced, today I am wearing a black suit jacket, a blue and white shirt. I have very large gaming headphones on due to some unexpected noise in the background, and short brown hair, and I'll have Bradley introduce himself.
Hi, my name is Bradley Dunn. I'm a heavyset white male with dark hair, a full beard, gray on the sides but darker in the front. I have dark rimmed glasses. I'm wearing a blue suit with a white shirt and a bow tie.
So today we're providing a legal update, trending cases, new areas of law, what's been going on in the last couple years in the area of civil rights law. We are from the Ohio Civil Rights Commission, and so Bradley, let's go to the disclaimer page because we are lawyers. So we are lawyers. We are not your lawyers. We are lawyers for the Ohio Civil Rights Commission. We are talking about the law, but nothing here is legal advice. Nothing here creates an attorney-client relationship between you and us, or between the commission and you. As members of the Civil Rights Commission staff, we enforce the law. We do not write it. Hate the game, not the player. If you don't like the way the law is written, you have the legislature to talk to about that. We answer questions a lot with "it depends." That's because the law is complex. Life is complex. Every situation is unique and different. Small facts can change the outcome of a case. we're not dodging your question when we say that, but it really just does depend. But we can give you today lots of guiding principles. And if you have questions, we will assume your questions are hypothetical. We'll assume you're asking for a friend because we cannot give legal advice. And like I said, situations can be complicated. Many little nuances can change the outcome. So we're just going to be talking in hypotheticals if there's any questions here today.
All right, great. Well, now for our first topic. It's actually something that, truthfully, we're all likely sick of. Pun actually intended. And that is why we stuck it at the beginning, because like a Band-Aid, we want to hurry up and try and get the pain over with. That's coronavirus and updates. I know. And just like Jaws, just when you thought it was safe to go back in the water, but in this case, it's just when you thought it was safe to go to a conference and not hear about COVID, we're back at it. We're sorry to have to bring it up, but there has been some new guidance from the EEOC addressing a change in medical examinations. Now, the new guidance is creatively called What You Should Know About COVID-19 and the ADA, the Rehabilitation Act, and other EEO laws. And the link is on this slide, which, from my understanding, is available through the link that you received to get into this presentation. Now, I don't know who does regular COVID testing anymore, but if you do, or you feel like it becomes necessary to ask for a medical examination for an employee, this guidance was really made for you. Over the history of the pandemic, and until recently, actually, the EEOC standards for medical examinations were always met to conduct worksite COVID-19 viral screening tests. However, going forward, employers will need to assess the current pandemic circumstances and the individual workplace circumstances to justify doing a screening test on employees. The EEOC was kind enough to tell us what factors they're going to look into to see if you've maybe possibly violated the ADA in conducting screening. And those factors are, but not limited to, community transmission levels, and the types of contacts between employees and others in the workplace. That was it. Not exactly a long or specific list, but that is what the EEOC has laid out as what they're going to be looking at. Now, notwithstanding this new guidance, the EEOC does indicate that the ADA would not prevent an employer under any circumstances from asking employees if they have any COVID-19 symptoms. It would not be a violation to require employees to furnish a negative test as a condition of returning to work after testing positive, or otherwise follow CDC guidance to determine whether it is safe to allow an employee to return to the workplace without confirmation from a medical professional. Now, as a side, since I did bring up the CDC, or more correctly, the EEOC did, the CDC recently indicated in some of its guidance that if an employee is exposed to a positive COVID patient, we're at the point in a nationwide level of vaccinations that employees do not have to isolate regardless of their vaccine status, which is a slight change. And I would encourage you to follow up and look at the CDC guidance for more details on that. But that's an interesting development that occurred actually while we were putting together this presentation. The guidance recognizes the CDC's own guidance has changed radically over the pandemic, and so has actually American behavior. The guidance combined with American behavior means that impacts us in a couple ways when it comes to the ADA. Number one, it means the concept of direct threat has become more of a macro issue in a way that it was not before, and making that direct threat defense argument harder to justify an employer's actions. Now, direct threat, as a reminder, is a basis for denying a reasonable accommodation because either the medical condition of the individual or the requested accommodation poses a direct threat, not a speculative threat, but a direct threat to employees or others, to the employee themselves or others, sorry. Direct threats still exist with respect to a particular individual who's at increased risk of consequences should they get COVID. However, the guidance, which comes from the CDC, can really only focus on hospitalizations now, because so few people are getting COVID tests through their health departments and now taking at-home tests and not following up with health departments to report positive or negatives. The CDC is having to rely on hospitalizations, as well as many other factors, including American behavior. It has become more difficult to apply the direct threat defense using COVID as a basis compared to throughout the pandemic. So that's kind of a big change there. Now, I like to read this as things are getting better. You know, just because you may have been exposed to COVID, you have COVID, COVID's in the mix, does not mean that you can rely on a direct threat, a la you're not as much of a direct threat as you were during the pandemic. Yay! Well, I do not want to disillusion any of you, however, into thinking that I'm simply a bearer of good news. You know, someone who doesn't allow for the strain of a reminder of remain vigilant and, you know, warning and wearing us all down to that reminder. So in that spirit, I want to remind you, remain vigilant. Yeah, continue to. While it appears that the global pandemic indeed is winding down, that doesn't mean that this will remain true in the future. The CD guidance can actually change in a matter of moments. When we look at something like the BA.5 Omicron variant that's currently spreading around, it's become actually quite prevalent. It's very contagious. Although, on the other hand, it also appears to be a much less potent version. So we have an offsetting there. However, just be aware that that can change. So again, be vigilant, be prepared for changes at any time, and make sure you follow up with the EEOC and the CDC for any advancements. Now, the one thing that has remained the same and is unwavering in the pandemic is, for reasonable accommodations, the importance of the interactive process. It remains just as critical as always. And the reason that it is critical is that what is some of the aspects of what was not reasonable prior to the pandemic may have changed. To wit, 60% of legal professionals no longer want to work in the office full time. They want a hybrid office working environment, some remote, some in office. For all kinds of employees, that number is close to 50% do not want to work full time in the office. So expect a lot of telecommuting reasonable accommodation requests. And again, the reason that this becomes a little bit impactful here is, remember, you know, in 2019 BC, that stands for before COVID, teleworking and remote working almost universally was not seen as a reasonable request. In-office attendance was almost always seen as an essential function of the position, which means that you can't eliminate an essential function. That would be unreasonable. However, post-COVID, after we for 2 years pretty much existed in a telework environment, you know, that argument is not as strong anymore. So just be aware of how that interactive process may have changed. Another highlighted change is, while the EEOC talks about how the accommodation process may still be understandably delayed because of the pandemic, remember, an unreasonable delay for, you know, if it's unreasonable in granting an accommodation is still actionable. That is still a violation. So as the pandemic winds down, the excuse of, well, we're delayed in granting or denying a reasonable accommodation because of the pandemic also winds down. So just be aware of that change. Okay. Despite the guidance adding some clarification, there are some aspects in going through it that appear to still to be a little bit hazy. And the one that was glaringly hazy and that I'm going to be working to find out is when the EEOC talks about who's fully vaccinated. Does that mean you've received 2 shots and a booster, 2 shots And 2 boosters, what is the definition of fully vaccinated? That remains undefined. So there are some ambiguities out there that if you keep your ear to the railroad track, you may hear that answer come down the line. I'm not the only one that has highlighted some of the ambiguities here. All right, now let's switch gears a little bit and let's talk about reasonable accommodations, the ADAAA and reasonable accommodations. Now, reasonable accommodations for disabilities remain a sticky wicket for the courts to handle. In the past, this actually led to the passage of what we now know as the Americans with Disabilities Act, Amendment Act of 2008. And yes, that is right. They threw in the word act twice for whatever reason, but also known and usually referred to as just the ADA. The technical title is the ADAAA, however, and I will refer to both as I go forward. So when that Amendment Act was made, because the Congress got frustrated with the way that the courts were interpreting the ADA, it passed with a laid out set of rules of construction. Basically, Congress was saying, you got it wrong, so this is from now on, this is how we want you to interpret the ADA. Despite this change, the courts are still inconsistent at times with their interpretations. For example, let's take a look at our first recent decision that we're going to discuss today. Hopman versus Union Pacific Railroad. This is a case out of the 8th Circuit, and it discussed how being free from pain is not a privilege of or benefit of employment. And reasonable accommodations are not reasonable unless they help the employee in performing the duties of his or her particular job. Now, while it is generally agreed upon that reasonable accommodations involve the removal of workplace barriers, thus non-workplace barriers are generally outside of the employer's reasonable obligations, other courts have disagreed with the 8th Circuit in rather germane ways. For example, by contrast, the DC Appellate Circuit states that reasonable accommodations also includes modifications so an employee can work without severe pain. Specifically in Hill versus Associates for Renewal in Education, the court held the employee, a teacher who had a prosthetic leg, had been entitled to a reasonable accommodation so he could supervise his students without prolonged standing. Although the employer tried to argue that the employee could stand with pain, the court noted requiring the employee, quote, to work with pain when that pain could be alleviated by his requested accommodation violates the ADA. So we can see here that there is some disagreement among the circuits as to what the ADA does or does not stand for, what it does or does not mean. So what I would say is pay attention to the circuit in which you do business. And for most of us, I would assume that's the 6th Circuit. Now, here in Ohio, we have a case where the plaintiff, Caldwell, was diagnosed with fibromyalgia, multiple disc issues in her back, plantar fasciitis, chronic ankle tendonitis, back pain, anxiety, and depression. Her physical conditions began to affect her ability to work, and eventually she was permitted to use a motorized scooter to go to class, back and forth between classes, but was denied usage of the scooter in class. And the school cited that it was a safety hazard, that thing that we talked about earlier, that direct threat. The employer also asked Caldwell throughout this process to provide a doctor's note, and I want to draw attention to this, showing that she had no restrictions. After attempts to be accommodated were denied, Ms. Caldwell resigned, alleging a constructive discharge of her employment. In other words, the conditions were so bad that she had no choice but to resign. The trial court actually granted the school's summary judgment, noting that Caldwell was unable to show that the employer took an adverse employment action, focusing on the facts that she voluntarily resigned, and the denial of one reasonable accommodation is not a quote-unquote adverse employment action. Further, the trial court noted that Caldwell ended an interactive process when she resigned. Ms. Caldwell appealed, and the appeals court came back and said, wait a minute. The charging party's alleged denial of a reasonable accommodation, means that she was not able to perform her position's duties. She was denied one reasonable accommodation, but she was repeatedly denied that reasonable accommodation. And noting that the school was requiring her to return to work without restrictions, all of this led to a constructive discharge, which, legally speaking, is an adverse employment action. Regardless, the court comes back and says, regardless of that, the court messed up, the trial court messed up because a reasonable accommodation never requires an adverse action like other alleged employment actions, just a denial and no evidence of undue burden. So the initial finding was reversed. And then finally, we're going to take a look at a situation where nobody disagrees that the plaintiff's actions were motivated because of her disability. Now, this one gets a little saucy, all right? So Harkey was hired in March of 2008 and worked without incident for over a decade. On October 10th of 2018, she was attending an out-of-town national sales conference for NextGen, and it was at a large hotel in St. Louis, Missouri. After dinner and a few drinks with some coworkers, Harkey headed up to her room. She watched some television, fell asleep. Scott O'Donnell, also a NextGen employee who was married, returned to his room from the hotel bar around midnight when he heard a knock at the door. Who was there but Harkey? Odell claims that Harkey was standing wearing a black cotton robe, barely wearing a black cotton robe because it was around her knees and she was otherwise naked. She didn't say anything to him, and without looking at him, I went forward too quick, sorry. Without saying anything to him, she entered the room and got underneath the covers of the bed. He, throughout this process, is protesting, you're in the wrong room, you need to get out, stop, etc. Now, there was no conversation between the two. She just came in, went to the bed, fell asleep. Well, continued sleeping. O'Donnell retrieved the supervisor, Sean Murtagh. Murtagh didn't recognize Harkey, so he ended up contacting the HR director, Jill Burke, who was also attending the conference. When Burke arrived, she attempted to wake Harkey repeatedly. Eventually, she was able to wake Harkey. She was disoriented and smelling, as it was reported, smelling of alcohol and exposing skin, quote unquote. Hotel security got involved, and Harkey ended up becoming very apologetic, was embarrassed. It was learned that she was a NextGen employee and communicated to the HR director that she must have been sleepwalking, which she had been done from the time she was little and is a disability that she has. Now, at some point the next morning, she was asked to go to a conference room where she met with the HR director, who indicated she was in big trouble, needed to be concerned. After discussing the incident, and again, Harkey explaining that her actions were directly the result of her sleepwalking, she was fired. Now, after she was fired, she filed suit alleging that she was her event was the direct result of her sleepwalking. Now, the court noted that, I'm sorry, I got ahead of myself again. Basically, at this point, the case was dismissed when it was filed. And the court noted that the ADAAA does not insulate emotional or violent outbursts blamed on an impairment. Plaintiff's severe, unprofessional, and inappropriate conduct was caused by her sleepwalking disorder is of no matter, as the ADA does not give employees license to act with impunity and a decision was upheld in the employer's favor. So just because somebody is disabled does not give them a get out of jail free card, I guess is the lesson you'd walk away with that. Now we turn to the subject of retaliation and Attorney Limbert.
So I'd like to start by reminding everyone of Ohio's definition of retaliation, because our case that I'm going to talk about is, it concerns how broad that definition is. So Ohio law prohibits retaliation against any person because that person has opposed any unlawful discriminatory practice, or because that person has made a charge, testified, assisted, or participated in any manner in any investigation, proceeding, or hearing, under RC 411201 through 07. Now that's Ohio's definition, but as you probably know, when we are interpreting Ohio's civil rights discrimination laws, we also look to federal law, which is why we're looking at federal cases today. And so with that definition in mind, let's look at a federal law case. This is Marie Patterson versus Georgia Pacific. And this concerns whether there's an HR manager exception that allows employers to retaliate against HR. So Jacqueline Patterson was working as a human resources manager for Georgia Pacific. We'll call it the new employer. She, however, had been involved in a proceeding at her former employer where she gave deposition testimony. She was a witness in a pregnancy discrimination lawsuit against her former employer in her role as an HR person in that former employer. A week after her new employer, Georgia Pacific, found out that she had participated by testifying in this pregnancy discrimination lawsuit with her former employer, she was fired. And in that conversation, her HR director asked her, in regard to her deposition testimony, did you support or go against the employer? So Patterson says she testified on behalf of the ladies, meaning the charging parties, the complainants. The HR manager said she went against the employer and that having done so made things clear to him. The trial court granted summary judgment to the employer, Georgia Pacific, saying that Ms. Patterson, the plaintiff, did not engage in a protected activity because, first of all, she was in a role as a manager, and second of all, it was against a former employer. She wasn't testifying against her current employer. This has been deemed, at least by the appellate court here, as the manager exception. And the trial court said a management employee in course of job performance disagrees with or opposes the actions of an employer, does not engage in a protected activity. And when she was involved in the termination of an employee for her previous employer, that was part of her management role. So participating in a deposition relative to that was not a protected activity for her purposes of her new employer, Georgia Pacific. In the alternative, the trial court said she wasn't opposing Georgia Pacific's employment practices. She was just opposing discrimination generally, so that's not retaliation. The appellate court disagreed and reversed. And again, this is federal law, but it's similar to the Ohio statute. The statute in place says oppose any practice made an unlawful practice. There's no carve out for what practice is being opposed, whose practice it was, former employer, current employer, or what your role was, whether she was for or against the people alleging discrimination, as her HR manager so put it. So the lesson here is actually summed up really well by the court. Opposition is opposition, whether the opposer is drawing a manager's salary or not. And any practice means any practice. She's opposing discrimination in some form, any person, any discriminatory act. So remember that retaliation is probably broader than you think. Our next topic here is LGBTQ plus guidance. For a short moment, we had guidance from the EEOC on some of the emerging issues in LGBT plus employment related issues. And this EEOC guidance stemmed from a presidential executive order from January 2021. It followed the Bostock reasoning and said, hey, federal agencies, you need to implement rules prohibiting sex discrimination on the basis of sexual identity or gender identity and sexual orientation. So the Department of Education and the EEOC issued guidance explaining their interpretations of Title IX and Title VII. Here we're talking about the EEOC, not Department of Education. So the EEOC issued a technical assistance document explaining what the Bostock decision meant for LGBTQ plus workers and employers, and explained the EEOC's position. It provided examples of what might constitute discrimination, including not limited to dress codes, bathrooms, locker rooms, showers, use of pronouns, use of names. The document itself specified that it did not have the force and effect of law, not meant to bind public opinion or bind the public to this is the EEOC's official interpretation. It was supposed to provide clarity regarding existing requirements of the law. And importantly, for the analysis, the full EEOC, the commission, did not approve the document by a majority vote. It didn't go through a rulemaking process. So several states sued, seeking an injunction to prevent this technical assistance document from being implemented. They argued it was unlawful rulemaking. The EEOC did not go through the proper channels. It was not voted on by the commission. The EEOC can't apply it. And the court agreed and issued an injunction saying this policy doesn't have the effect of law, just like it said it didn't have the effect of law. So it wasn't intended to be rules. It was intended to elaborate on what the current law is and how the EEOC might interpret it. But regardless, we no longer have that guidance document having whatever effect it had because it's been enjoined. One last point is that employers should know that this does not stop employees from asserting Title VII claims regarding the things I just mentioned and others: dress codes, misgendering, bathroom use, pronouns, and the like. Just because this technical assistance document is enjoined doesn't mean employees can't raise those issues. This is just that the courts will have to step in and answer the open questions from the Bostock decision.
Okay. All right. I'm sure all of us are aware of the Supreme Court's decisions that have come out recently, specifically the 50-yard line praying case and the reversal to Roe v. Wade and Casey. For the prayer case, we want to provide some clarification, because when we saw this case come out, we saw a lot of the media outlets indicate what this case does or does not mean for employers. So we want to provide a little bit of clarification in relation to employment law. And for the latter Roe case, which we don't normally weigh into, we're not going to here, we want to indicate how that decision may impact the workplace through state civil rights law. Okay, first, Kennedy versus Bremerton School District. This is the 50-yard line school prayer case. First, it's important to note that the case would not apply to private employers. This is a First Amendment case, and the First Amendment applies to government actions. It just happens to be that as a school district here, the government was the employer. So that's how it got into the form it is. Next, there had been numerous news reports that seem to imply that the United States Supreme Court has opened the floodgates and allows teachers and coaches, and thus, I guess you could say by extension, managers and public government, to encourage students to pray with them. Well, that is not what the finding states. Indeed, the decision specifically states, quote, "The contested exercise here does not involve leading prayers with the team. The district disciplined Kennedy only for his decision to persist in praying quietly without his students after 3 games in October of 2015. Indeed, the court went on to warn of a different result could have been possible if it was deemed to be government speech. In agreeing that there is a limit to free speech in government employment, the court states, quote, "But the teachers and coaches are also government employees, paid in part to speak on the government's behalf and to convey its intended messages. When an employee speaks as a citizen addressing a matter of public concern, the employer must engage in a delicate balance of competing interests surrounding the speech and its consequences. When Kennedy uttered the 3 prayers that resulted in his suspension, he was not engaged in speech ordinarily within the scope of his duties as a coach." Basically, the moral of the story is the court, although media outlets wanted to make it look that way at some points, did not reverse the ability of an employer to stem religious speech when an employee is acting on behalf of an employer performing their governmental duties. So just as an advisement and point of clarification. Now, that next case describes the way, one way, I should say, the abortion debate may impact the workplace. First, understand this is not a constitutional rights case, as Dobbs was, the case that overturned Roe v. Wade. Rather, this is a religious discrimination case that prohibits an employer from discriminating against an employee because of religion. Employers rightfully can have rules. We all have rules. But it would be impermissible to create rules that intentionally limit, segregate, or classify employees based on the presence or absence of religious beliefs, observances, or practices, or to enforce a neutral rule that has the same effect of limiting, segregating, and classifying an employee based on their religion. So what happened here is the plaintiff had a religious belief requiring her to share with others her pro-life stance on abortion. This upset a number of employees who complained to the union. The union therein complained to her employer about her pro-life posts on Facebook. Now, those posts were made, in her own time. The union was found to have violated Title VII of the '64 Civil Rights Act by trying to get the plaintiff fired over her religious views, and the employer violated Title VII when it did fire her because of her pro-life social media content. In effect, the company and the union took a neutral rule and bent it to discriminate against the plaintiff because of her religion. Now, on the other end of the sliding scale, this case involves an employer who forced employees to participate in religious observances. So we have the other end of this scale. Specifically, the employees were, in keeping with the owner's religion, made to scream at ashtrays or stare at one another for 8 hours without moving, attend courses on religion, and undergo an e-meter audit and purification. While there was no ruling in this case specifically, the employer did have to dish out some significant number of dollar bills because of the action. So don't bring your own religious views in and force your employees to abide by those religious views. So thus far, we've discussed religion in the context of government actors, non-governmental actors, assuring that your rules are uniform and they're applied as such. Now let us look at the other aspect of religion, and that is reasonable accommodations. Now, the other area, if you'll recall, where reasonable accommodations come into play is through disabilities. And as with disability, an employee can request a reasonable accommodation based on religious beliefs. And just like a disability, if the employee requests a reasonable accommodation, the employer generally has to grant a reasonable accommodation, not necessarily the one requested, just a reasonable one, unless the employer can show an undue burden exists. And again, this is all assuming that the reasonable accommodation requested was indeed reasonable. However, unlike disability, the threshold for an undue burden under religious accommodations is merely showing a de minimis amount of burden. That is literally translated as of minimal. And we're going to see that play out in this next case, Gerald Gruff versus the United States Postal Service. Now, the plaintiff was, and presumably still is, a Sunday Sabbath observer whose religious belief dictates that Sunday is meant for worship and rest. As a result, plaintiff informed his employer he could not work on Sundays. And truthfully, throughout most of his employment, that was not an issue, as the mail did not run on Sundays. However, the United States Postal Service began Sunday deliveries due to a contract that they formed with Amazon, and the plaintiff was required to start delivering on Sundays in contravention of his religious views. To accommodate or attempt to accommodate him, the employer offered to find employees to swap shifts with him and indicated that he can find employees to swap shifts. And truthfully, shift swapping, as we've heard earlier today, can be a reasonable means of an accommodating, and here accommodating a religious practice, but it didn't work here. On more than 20 Sundays, no co-workers would swap, and the plaintiff didn't work. And when he didn't work, the defendant disciplined him. Eventually, the plaintiff just resigned and filed suit alleging the employer denied a reasonable accommodation of refusing or failing, to cease issuing discipline when he was engaging in behavior because it was known to conflict with his religion. And the suit that was filed, the result was the employer was shown not to have violated the law. Why? Well, the employer attempted to provide a reasonable accommodation, And the court noted that not issuing discipline would not be reasonable. Moreover, not scheduling the plaintiff to work when all did work these shifts also was an undue burden upon the company.
All right, if you attended Darlene Sweeney Newburn's OCRC 101 presentation this morning, a question was asked, what are the most common cases the OCRC is seeing in the last year? And I think she rightfully answered disability and race are the most common. So we've got a couple of cases here that we'd like to talk about race and specific to hostile work environment. And as a backdrop, I'd like to remind everyone something that I've been with the commission 8 months, but I still see it over and over again. The standard for hostile work environment is severe or pervasive. Not severe and pervasive, severe or pervasive. So if it's one of those things, it can be a hostile work environment claim. And so there's been recent case law discussing what level of comments, derogatory comments, based on a protected class in the workspace are enough to rise to the level of severe or pervasive. And with regard to race, it's really interesting some of the cases that have come down. This case, Anthony Woods versus Latoya Central, this is out of the Fifth Circuit from this year. The plaintiff said that the supervisor called him a lazy monkey AN in front of his fellow employees. And the court found that even though this is one statement that was made with no evidence of any others, this was an actionable claim of hostile work environment. The court said even one use of a severe epithet in the workplace may alter the conditions of a plaintiff's employment such that the environment is abusive in violation of Title VII. And remember that legal element of altering the conditions of a plaintiff's employment is very important when we're analyzing hostile work environment cases. Did the conduct rise to the level that the terms of employment are affected? And the court pointed out that this particular sentence uttered by the supervisor actually included several highly offensive terms. Sure, it was one sentence, but it said a lot of stuff in one sentence. And like I said at the beginning, facts are really important, and digging into the nitty-gritty of facts can really change the outcome of a case. Here, they considered that it was uttered by a supervisor, it was in front of coworkers, and it may have been part of a broader course of discriminatory conduct, even if other statements weren't made. So it depends. That's why when you're working with your counsel, when you're evaluating an employment case or situation you have in the workplace, you have to look at all the facts. You really have to dig in deep to make sure you understand the full situation. Next case is Lasana Kenny versus Chicago Transit Authority. Again, this is an example of one instance can be enough to be severe or pervasive, probably on the severe side. But in this case, there was a single instance of a noose displayed in the workplace, arguably directed at a particular African-American employee who had complained of race discrimination. Here, the lower court initially said that this one instance was insufficiently severe to support a retaliatory hostile work environment claim. The appellate court reversed, indicating that a noose qualifies as an extremely serious act of harassment based on race. It is meant to convey a threat of physical harm and to arouse fear in the person to whom it's directed. The noose in this context is a symbol not just of racial discrimination or disapproval, but of terror. And so it is severe, and just that alone can rise to the level of hostile work environment. I see there's a question here. If the staff member is disciplined for hurt actions or words, is management still to be held responsible for the actions? And I'm actually going to toss that to Bradley, put him on the spot here.
I don't understand the question. What is it again? If the individual is disciplined for words, is the management? Could you reread it? I didn't see it.
If the staff member is disciplined for actions or words, is management still to be held responsible for actions?
The staff member is disciplined for actions or words.
I think it might be going to what the level of the manager's response to the situation. If the staff member who said it.
I wonder if it can
Yeah.
be held liable in that is actually something that we're going to explore at the end. So I would ask that we hold off that question. We're going
Okay.
to address immunity at the very last slide. The short of the answer is yes, with a big asterisk near it.
We lawyers
So,
love asterisks.
yeah.
All right,
Depends.
so we'll put a pin in that and come right back to it. Next case here is Farisha Sims versus University of Maryland Medical System Corporation. And this is a reminder that there still needs to be a nexus between the acts and the protected class. In this situation, the plaintiff's supervisor allegedly got angry with her for failing a board exam. Supervisor called the plaintiff stupid for misinterpreting a workplace policy, denied one of plaintiff's vacation requests while granting similar requests to her coworkers, but there had been a legitimate non-discriminatory reason for those denials. And allegedly a coworker threw papers in the plaintiff's face because plaintiff was late to relieve the coworker of her duties. Here, the court noted that unless the behavior about which the individual is complaining is based on that person's protected class, the law isn't going to recognize it as a hostile work environment. And I like this quote here. We've cleaned it up a little bit, but it's the common denominator between these incidents that happened in this case is that the plaintiff provides no evidence beyond speculations that any of the actions she claims contributed to a hostile work environment were motivated by racial animus. She relies entirely on her own general statements to conclude these incidents were motivated by race. So there still needs to be that connection. There still needs to be a link to race. And while this subsection of our presentation is talking about race, this can apply to other protected classes too, religion, disability, anything that's a protected class under 4112. And this is a simple bullet point, but it says a lot. Race means race. It's not just one race or another race. The statute does not carve out one category of race as a protected class. So this case illustrates that point. This is an Ohio case, Holmes versus Cuyahoga County Community College, 8th Appellate District up in Cleveland. The plaintiff began with respondent in 2014 as a corporal. Plaintiff is white and reported to black supervision. Plaintiff became interested in a transfer corporal position. He was told if he did not apply for the open corporal position, his supervisor was going to promote a sergeant to lieutenant, and then plaintiff could have the sergeant position. Instead, the supervisor passed over the charging party, the complainant, for the sergeant position and filled the positions with African-American employees. Charging party and an African-American employee were later verbally chastised for an incident that happened in the workplace, but charging party was the only person reflected in the write-up, the disciplinary write-up. Plaintiff was also disciplined for an error an African-American employee committed, but they weren't disciplined. So in this case, respondent was shown to have promoted and hired African-American employees without posting the jobs, and so these issues survive summary judgment. So this case wasn't determined in this particular appellate decision, but it meant that summary judgment was reversed and the case went back for a trial. So race means race, any race. All right, turning to sexual harassment. Really important. If you take away nothing from this presentation, remember this. If someone alleges they were sexually harassed or harassed on the basis of any protected class, the employer should take prompt remedial actions. And we had a video clip in here, but I think we're going to skip over it. It's important to note that there can be a slight difference between sexual harassment and gender stereotyping. Both are bad, both are unlawful. Sexual harassment can be, the physical and comments about, sex. And then gender stereotyping can be things like you're not feminine enough, you're not masculine enough, you're a man, why are you wearing nail polish? You're a woman, you're acting aggressive and loud, and you're acting like a man. Those two things are a bit different, but they're both unlawful. This next case here is Christina Sansone versus Jazz Casino Company, Fifth Circuit federal case. Here, a customer, not an employee, but a customer made sexually charged comments to a plaintiff employee in front of others at least 2 times a week for several weeks. The appellate court had reversed the trial court's finding, stating that these comments were severe enough or were pervasive enough to support a hostile work environment claim. Remember, severe or pervasive. Here it was pervasive. And this is an example of how not to handle a sexual harassment allegation. Plaintiff offered evidence that the defendant had trained her to report her problems to the floor supervisors. So they had this procedure they had told the employee about, if you've got problems like this, report them. And then the floor supervisors were to move any complaints up through the chain of command. That's what the plaintiff did. She followed instructions. She brought her complaint multiple times, said, hey, I'm getting harassed by this customer. It was over a 3-month period. Defendant did nothing. Employer did nothing. The managers told her, ignore him, let it go, and then had gave an additional response that this comes with the business. If employers had taken prompt remedial action, perhaps this would have gone differently. But the continuing pattern of ignoring it and the behavior being so pervasive over so long led to a hostile work environment claim.
Hey, Christy, I don't think your slide progressed. Were you on a different slide?
No, that's where I was.
Okay.
I think I have more information than what was on the bullet. Yes. Thank you.
Awesome.
Though.
Okay.
So then Landry versus Leesville Rehab Hospital. I can't say it enough. It depends. We're giving you some examples of cases here, but facts can change analysis. In this case, we're reminded that when it comes to harassment, the nature of the job and the location and what you're doing on a day-to-day basis can be important. The type of acceptable speech on a production floor may not be similar to what's acceptable in an office environment. And specific to this case, this involved a nurse at a rehabilitation hospital alleging that a patient touched her inappropriately and made a sexually suggestive and racially inappropriate comment. The court noted that the harassment the nurse endured was offensive, but was not severe, partially or particularly because of the patient caregiver setting in this case. The court noted that patients who suffer ailments, mental incapacity, dementia, just mental, any kind of ailment that might cloud their judgment about what's inappropriate or not, and what's offensive or not, that can affect the analysis here if it's common in the profession, the industry. Also in this complaint, or in this case, it factored in that the complainant waited to complain until after she was fired. So again, we got to look carefully at the nature of the job too when evaluating these kinds of claims. And here, Lester versus ODRC, the employer failed to take prompt remedial actions in the face of a complaint that can lead to a violation. The supervisor, someone asked the supervisor, just keep this between you and me. I don't want you to do anything. Failing to fill out the proper form to make an allegation, that is immaterial. If a complaint has been brought to the employer's attention, even if the employee says, just keep it between us, I'm not filling out a report, the respondent is on notice. The respondent has knowledge. Here, Lester was a female quartermaster at a prison. She alleged she was harassed because of her sex after she returned from a leave by a guard who assaulted her, threatened to rape her, and then intentionally locked her in an enclosed area with inmates who had access to scissors, hammers, other tools that could have been weapons, and that he made sexist remarks to charging party and a supervisor. She filed a complaint, but the prison was slow in response and basically told them, suck it up. Eventually, Smith was told to stay away from charging party. So the bad actor was told to stay away from charging party, but respondent allowed Smith to be promoted to a position where he would see charging party every day. So respondent tried to argue that charging party complainant, we use that term because charging party is our term for initial charging parties. The complainant did not complain because she didn't fill out the right form to allege discrimination. She had told management, the management knew of the allegations, and it's new. The standard is new or should have known. You have to, once the employer is on notice or should be on notice, that's when your responsibility starts.
Okay. Well, because we started with COVID updates, we thought we'd end with an immunity update. Gladly, however, we're not talking about COVID immunity, but we're going to talk about political subdivision immunity, which I think is going to circle back to the question. Now, we'll take a look to see if we answer it through this presentation. If not, then we'll figure something out for you. All right, the case we have here is Darren Townsend versus the city of Kettering, down near Dayton, I believe. The exact facts of this case are somewhat irrelevant. We've been talking, Christy's been beating the drum about how, facts make such a big difference. And here, know that, yeah, facts do make a difference. But for our purposes of an analyzing the case, we don't need to go through the facts with a fine tooth comb. Just know the plaintiff alleged he was racially discriminated against by not having him promoted to a fire captain position in 2016. And he alleged that two of his supervisors, Butts and Miller, aided and abetting the city in his discriminatory and retaliatory conduct. And he had some evidence of that, some alleged racial comments to support his position. However, he alleged that all the defendants acted with intentionally, recklessly, and maliciously in the denial of his promotion. All right, so during the trial, two of the individuals moved for, Butts and Miller moved for a motion to be thrown out of the case because they were immune. Now, how would this happen? Well, there is a part of the statute, Revised Code 274403, that creates a presumption of immunity for government acts carried out by political subdivisions and their employees. Now, political subdivisions, cities, townships, it also includes government agencies, etc. So when you have a political subdivision that's acting in their role as a government actor, there's a presumption of immunity. There are three exceptions to that immunity, however. The first, that the employee's acts were manifestly outside the scope of employment. Next, or second, the employee's acts were done with malicious purpose, bad faith, or in a wanton or reckless manner. And then the third exception, exception to immunity, civil liability is expressly imposed upon the employee by a section of the revised code. So you either have to have an employee that's acting outside the scope of employment, acted with malicious purpose, bad faith, or reckless, or there's some code, statutory code out there that expressly imposes liability. Now, the trial court, when Butts and Miller moved to be excluded from the trial for alleging that they're immune, denied the motion, saying basically that their discrimination that they engaged in is outside the scope of employment. And they also indicated that the employees' acts were malicious. So for two reasons. One, they said that they're again, outside scope of employment, and it was malicious. So it met two of the reasons. Jiminy Christmas, sorry about that. I keep jumping all over the place for the exemption. Now, the Butts and Miller appealed this decision. And when it went to the appeals court, they upheld what the lower court had found. However, with an exception, and that is that they found that the grounds that they found that it didn't apply was wrong. The appeals court indicated that just because an employer does not pay an employee to discriminate does not mean that what they were doing when they were engaging in a discriminatory behavior was outside of the scope of their employment. Moreover, the appeals court, while finding that the acts of one of the actors was malicious, they did not find that for the other. But again, I said that they upheld the lower court's decision. And the reason being actually comes back to something that the lower court never even brought up at any point in time, and that is the third exception, that there's a civil liability that is expressly imposed upon the employee, and kind of the purpose of bringing this case in today. Because the appeals, because the statute under 4112, the state civil rights code, has a particular provision under O2J that that if you're accused of aiding or abetting an entity with discrimination, you can be named personally, because instead of employer liability, as an individual, you can be named because it says any person that aids and abets can be named. And because the case had been filed alleging O2J, the aiding and abetting, the immunity exception applied, thus being no immunity. So as a cautionary tale, as you know, I've seen some people get excited, younger attorneys, not newer to the practice, that want to argue this statutory prohibition under 274403. However, we usually have to point out there's an exception here. Not only that, but let's go back and talk about the city, why the city didn't apply. Well, 4112 02A makes it unlawful for an employer to engage in discrimination. So there's personal liability for the city alone. Under J, as I said, if you aid and abet what the city is doing, which was alleged, then you can be held personally liable, which was pled here. So basically, there is a waiver of personal liability, something to be aware of, not only just for in the past. We had something called a Gennaro case that indicated that personal or managers could be named in suits. Well, that has been eliminated through recent amendments to the employment law under 4112. So that no longer exists, but we still have this 4112-02J that if you're accused of aiding and abetting, not only could the manager be personally named, but any employee may be named. All right, now I'm going to move on to the thank you screen, and I'm going to minimize so I can see the chat and to see what the actual question was. Or maybe...
Oh, there was, yeah, I was just giving a time check. We're at 8 minutes now.
Okay, so good. We made it. We didn't go over time, Christy. I'm proud of us. So are there any questions? I'd like to address the one.
Not bad for two lawyers.
Yeah, I would like to address the question that was asked earlier, because I don't know if I answered it, so I want to make sure. You see, conversation. Is the staff member, if the staff member is disciplined? Okay, I'm gonna, for Philip, very good question. I think what you're asking, and please let me know if this is not what you're asking, and I'm gonna go back to what I said previously. There was some recent amendments to 4112, otherwise known as House Bill 352. And through House Bill 352, what they did was they eliminated that Gennaro exception. So managers were no longer considered employers, which in effect was what Gennaro kind of a roundabout way said. So you could individually be named as a manager underneath the prior 4112 statute. When they came in on April 15th of 2021, they eliminated that. And I know that there were a couple local blogs that basically professed that, well, now individual liability is out the window. However, there were a number of plaintiffs' blogs saying, whoa, time out there. What about this provision? And actually, prior to the amendment of the employment statute, I could safely say very little used provision, at least through the commission, of 4112-02J, and aiding and abetting. General term, it has many more applications than just aiding and abetting. I'd indicate, please look at it. But it basically still has personal liability for anyone, not just managers, but coworkers, et cetera, that are alleged to have engaged in aiding and abetting in the discriminatory acts that have occurred to an employee. So in that sense, yes, individuals still can be held individually liable for their actions in a discrimination suit that's carried forward. Now, for the purposes of filing with the commission, you know, that has always existed, that J section. What we have seen, though, is an explosion of new J cases that we never saw before, because a lot of attorneys are wanting to make sure that they exhaust their legal remedy, which is now required by the statute, before proceeding on with a right of private action.
I think there might be one other way to take this. So just to cover, I think that was the intent, but just to cover all bases.
Yeah.
An employer taking prompt remedial action is a very good thing. And so if the question is geared towards, is the employer liable if they took action to, discipline the employee for actions or words that they said that were discriminatory, to make sure it never happened again, that's going to weigh in the employer's favor.
Oh, so I see what you may be asking is, does the affirmative Ellerth, I'm blanking out here, Farragher-Ellerth defense still apply? And I would say yes, and even more, when they amended the statute, they've added a statutory provision that explicitly indicates that if you have a policy, you communicate it, well, doesn't say all this, but in general, it says if you have a policy, you explain it to people, and then the person fails to avail themselves of that process, the employer has a affirmative defense to an allegation of sexual harassment, et cetera. So it's a statutory provision now. And I'm blanking out. I can give you that provision real. Well, actually, I brought it up there. You can take the journey with me. Underneath, there it is, 4112-054, affirmative defense to sexual harassment claim. There is now a statute that basically lays out, as long as you
Uh-oh, did we lose him? Christy, Bradley, are you guys?
Am I still there? I heard his voice.
Okay.
Oh, did I break up?
Here you are. Yes. I hear you now.
Oh, it was going fine on my end. I apologize if I broke up here. All right,
are there any more questions?
Yeah.
No? Okay. Well, Bradley and Christy, thank you so much for this fantastic session. And we want to thank everyone for attending. We have enjoyed this session. For participants, if you have additional questions or you would like to request slides or presentation materials, you just need to email odi@das.ohio.gov. We'd also like for you to share feedback on this session using the link provided in the Q&A. It's 2022 Inclusion Conference Survey, so you should be receiving that in just a moment.
Ms. Lee?
Yes.
If I may, and thank you for having us, by the way, but I wanted to insert a selfish little plug here, if at all possible. The Ohio Civil Rights Commission is going to be holding its first ever OCRC Academy this November 30th and December 1st. And through that academy, which is the brainchild of our executive director, we're going to go over protected bases. We're going to go over the structure of the commission. We have parts to an explanation of what department does what. So if you're having a problem, who can you call more effectively to get the answer that you want? We've thrown in practical activities I'm very excited about this. In fact, I'm making sure that I'm involved because I think it's going to be enjoyable, informative, and fun. So I hope you all will join us. We are limiting the attendance. So when you see the advertisements for it, make sure you sign up sooner than later. Thank you very much, Miss Lee. I appreciate it. And I
Thank you,
applaud
thank you. Can you
everything
give us
that
those dates again?
it
Bradley,
is
can you give us those
November.
dates again?
Sure, thank you. Yeah, November 30th and December 1st. We are
Awesome.
looking at around a possible 10 hours of CLE credit that we're going to try to apply for. So it's pending.
Awesome. Thank you so much. You guys have been wonderful, and this was a very informative and fantastic session. Have a wonderful afternoon, everyone.
You also. Thank you. Thank you all.
Thank you all.
Bye-bye.